Good afternoon. I'm Jim Duff, the Executive Director of the Supreme Court Historical Society, and I'm delighted to welcome you to our virtual platform for today's program. Today, we're with Professor Alison LaCroix in celebration of the publication of her new book, which actually comes out today. It is titled The Interbellum Constitution, Union, Commerce, and Slavery in the Age of Federalisms. And yes, it's federalisms plural for a good reason, as you will learn today. It is published by Yale University Press. Alison LaCroix is the Robert Newton Reid Professor of Law at the University of Chicago Law School. She's also an associate member of the University of Chicago Department of History. She is a scholar of U.S. legal history, specializing in constitutional law, federalism, and 18th and 19th century legal thought. In 2018, Professor LaCroix was awarded a National Endowment for the Humanities Fellowship. She is also the author of The Ideological Origins of American Federalism, Harvard University Press, 2010. In 2021, President Biden appointed her to the Presidential Commission on the Supreme Court of the United States, where she performed admirably. Professor LaCroix holds a PhD in history from Harvard University, a JD from Yale Law School, and a BA summa cum laude in history from Yale University. She joined the University of Chicago faculty in 2006, having previously held the Samuel Gottlieb Fellowship in Legal History at New York University School of Law. Professor LaCroix has served as a member of the board of directors of the American Society for Legal History, and she is a member of the editorial advisory boards of the Journal of American Constitutional History and the American Journal of Legal History. We're delighted to have her with us today. We'll be taking questions from our audience as usual at the end of her remarks, and you can share your questions in the Q&A box on your Zoom window. I am so looking forward to this. I enjoyed reading your work, Professor LaCroix, and I would start with a quote, but I'll get out of the way and let you speak about it. What I found most interesting was your incredible depth of research that went beyond just studying constitutional amendments, which weren't present at that time, during this period, but rather digging into judicial opinions and attorneys and viewpoints and arguments and attorneys general's work in this era. It's a remarkably detailed study, and we're anxious to hear all about it.
Wonderful. Well, thank you very much, Jim, for that introduction. And thanks also to Jennifer Lowe for inviting me to be here to speak to you today, and to Graham Pizzi for coordinating today's event. And I'm delighted to be here today. And yes, Publication Day is eventful because I think this is a wonderful audience and forum to talk a bit about how the United States became the federal union that we know today, and to bring back into the spotlight this era of what I'm calling the Interbellum Constitution, which is between the founding and the Civil War. And these decades between 1851 and 1861 are flanked by two wars, the War of 1812 and the Civil War. But the domain within that period tends to get overlooked. I argue, though, it was the origin point of a lot of what we now think of as modern constitutional law, especially with respect to relationships among levels of government, which we now know as federalism. And as the subtitle posits, we should think of as federalisms plural for this period. And I also like this moment to think about the history here, because this is a historical account. It's a story about legal doctrine, but it's also about many of our most current and hard-fought political debates and struggles that we're seeing around us right now. So controversies over who governs at the southern border, regulation of abortion, voting rights, firearms, healthcare, immigration, to name just a few. All the issues at the center of public debate today have their roots in this interbellum period. all these controversies at some level or another involve questions about federalism. Which level of government is to govern given our system, which has multiple levels of authority? So the interbellum period laid out much of the federalism landscape that we now know today. It was formed by constitutional structure. It was formed by doctrine coming from the courts. It was formed by practice or historical gloss, as we might think of it, and by text, and also by debate. So one of the things I tried to do in the book was really excavate and dig into debates in courtrooms, in Congress, but also in the public square. Letters, diaries, pamphlets, newspapers, and private correspondence that never made it into the public square. One of the central arguments the book makes is that constitutional law itself was changing in this period, that there was actually something called an interbellum constitution. And I also argue that the principal intellectual and doctrinal terrain on which it took shape was commerce, the idea of commerce as something in which people engage, so an activity, an everyday pursuit, but also, of course, the Commerce Clause of the Constitution's Article 1, both of these as frameworks for understanding how day-to-day activity and also regulatory authority was to be encouraged and was to be shaped. So in my remarks today, I'll proceed in three parts. First, I'll sketch one of the chief contributions of this interbellum period to American law, the creation of a constitutional law of commerce, which we now know quite well today. Second, I'll connect these changing ideas of commerce to broader debates in the period about what American federalism was supposed to look like. And finally, I'll discuss a 19th century case study in the relationship between commerce and constitutional structure that highlights the many meanings that this word commerce possessed in the period. And a lot of those meanings have been lost. We don't really think of them today, but the fact remains that they were not only once thinkable, but they were also foundational features of the constitutional landscape. So first, the creation of a constitutional law of commerce. So one central claim the book makes is that our standard story of American legal and political history is incomplete in a few important ways. First, it's chronologically incomplete because it focuses too much on two and only two great moments: the founding period of roughly 1787 to say 1790 or 91, and the Civil War and Reconstruction, so 1861 to 1877, perhaps. Now, clearly, the founding and Reconstruction are two of the most important events in American constitutional history prior to the 20th century. The founding was the point of origin, Reconstruction the moment of reckoning, or as the historian Eric Foner has called it, the second founding. And I'm just going to share my screen here because I have some images to show as well. So one thing that I think is quite notable about this period is that we're not necessarily focused on the right thing if we're only looking at these moments. We should be looking at this, what I think of as a 4-decade-long argument. And here we have a map of the United States in 1824, 200 years ago, right in the heart of this interbellum period. So I think it's important for us to recognize that the period between 1815 and 1861, between the two wars that are the framing devices of the study, that this period was a constitutional era unto itself. It wasn't just the hangover from the founding, the post-founding period that went on for some number of decades. And it wasn't merely the prelude to the Civil War. We're talking about a 46-year period, and they contained within them a really unparalleled period of creativity and crisis in constitutional thought. So the constitutional world looked different in 1861 from how it had looked in 1815. And the standard account of American constitutional history is also incomplete in a second sense that's more substantive. It overlooks the significance of debates about commerce, meaning trade and money and exchange in a broader sense, to the struggle over the nature of the union that defined the period. A widely shared imperative to create a new type of political entity that contemporaries referred to as a commercial republic elevated arguments about ferry boats, hogsheads of liquor, bales of textiles into questions of constitutional significance in a way that I think to us looking back seems logical. Of course, those were constitutional questions, but for people living in the period, it wasn't obvious that these disputes would be framed as issues about the Constitution. So everyday commerce created a lot of conflicts, and the language of the Constitution over these decades gave citizens, lawyers, judges, others, the rhetorical tools to escalate the arguments into something called constitutional debate. And as many people on this in this session will perhaps recall from reading or from study, the Commerce Clause has become one of the main areas in which the modern Supreme Court confronts the complexities of this relationship between the federal government and the states. But the interbellum period shows us why and how this happened, and frankly, makes it a little bit remote and unpredictable in ways that I think are useful to estrange ourselves from this very, very familiar concept of the Commerce Clause. So here we have an image from 1800, sneaking in a little bit before the period the book actually begins in 1815. The title is Preparation for War to Defend Commerce, which I think has a lot going on in it. And here in the image, we see a Philadelphia shipyard bustling with work on one of the new nation's new frigates. The title, Preparation for War to Defend Commerce, shows us from the outset, 1800, and this is President Jefferson's Tripolitan or Barbary War. From the outset, the idea of commerce was linked with the imperatives of nationhood, trade, foreign affairs, and in some instances, war. During this period, despite the many controversies that split Americans and even polarized them, to use a word that we hear today quite a bit, there was one point on which nearly everyone agreed, that the United States was a union, and it was a union with commerce, again, in a very broad sense. Even Southern slaveholders agreed with this proposition, and indeed their livelihoods depended on it. As we can see in these cover images and title pages from one of the most widely circulated periodicals of the interbellum period, DeBow's Review, DeBow was publishing in New Orleans, very much in league with and furthering the interests of the slaveholding planter class, but it's a commercial project. And the image that we see on the right shows Columbia sitting with her shield, and she's sitting atop bales and barrels, and there's a train in the background, there are smokestacks, there are barges. So commerce is not in any way something that is distinct from the interests of slaveholders and of their efforts and their engagement with capitalism, as has been discussed by a lot of excellent recent historiography. So general agreement at a high level about something called a commercial union, but a lot of disagreement about what exactly a commercial union entailed and who governed it. And this is where very few people could agree in this period. So when early 19th century Americans thought about commerce, they might, of course, have thought about the Commerce Clause of the Constitution, actually 3 clauses, which grants Congress the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. The Commerce Clause and the debates surrounding it were the crucible in which these interbellum battles over this relationship between the states and the federal government boiled. And this was because commerce was everywhere in the early 19th century United States. So one English traveler coming over to the United States to travel around and make observations about politics and society was the English author and reformer Harriet Martineau. Martineau, traveling in the United States in the 1830s, observed in 1837, "It is very comprehensible to the traveler why this new country so far transcends others of the same age in markets and means of transport. The ports of the United States are, singularly enough, scattered round the whole of their boundaries. Besides those on the seaboard," Martineau wrote, "there are many in the interior, on the northern lakes, one of which is just a few blocks away from me here, Lake Michigan, and on thousands of miles of deep rivers. No nook in this country," Martineau wrote, "is at a despairing distance from a market." I think there are 2 very noteworthy elements of Martineau's description. First, she connects markets with means of transportation, and the transportation she has in mind is waterborne. She focuses on ports. They dot the map of the United States from the northern lakes to thousands of miles of deep rivers, culminating, of course, in the Mississippi River, which she spent a lot of time traveling around and up and down and writing about. So the country for Martineau and her contemporaries is connected by waterways. This is the Erie Canal, completed in 1825, and many others. waterways running between transshipment points, markets, ports, and other areas. And something else I think that's notable in Martineau's description is her phrasing. No nook in this country is at a despairing distance from a market, she writes. The idea that nooks, places, might despair if they are distant from markets is something she's thinking about. And the answer is no, the nooks don't need to despair. So Martineau presents commerce as having this emotional component as well. The sentiments of the people of this increasingly far-flung union, she thinks, can be harmonized through trade and commerce. 1 year after Martineau was writing, now in 1838, a young Illinois politician, Abraham Lincoln, struck a similar note. Lincoln was speaking to the Young Men's Lyceum in Springfield, Illinois, a wonderful kind of Tocquevillian public gathering. People would come and have refreshments, listen to speakers talk about the issues of the day, ranging from literature to politics. They would often eat ice cream, and they were mixed gender groups, which I think also made them quite appealing to the young people of places like Springfield. And Lincoln told his audience that American government was based on what he called the attachment of the people. Here, Lincoln's framing nationhood again in these emotional terms, attachments, which he sees as a sentiment. The government, he said, was imperiled when the best citizens suffered what he called an alienation of their affections from the government. And Lincoln's solution was for law, which he specifically identified as the Declaration of Independence and the Constitution, to become what he called the political religion of the nation. Lincoln's speech was somewhat caution-laden as well. It wasn't entirely optimistic. He was worried about the health of the nation's political religion in 1838. Alongside the optimistic promises of commerce came concerns about how the commerce was to be governed. And by whom? Where would the power over commerce lie? With which level of government? The states, or what 19th century Americans referred to as the general government, by which they meant the federal government. So now let's turn to looking at commerce as a battleground, the battleground of federalism in this period. Americans in the 19th century increasingly viewed commerce and these issues of trade and exchange as the domain, the battleground on which arguments about federalism would be conducted. And for interbellum lawyers, bringing cases, making arguments, questions of where federal power began and ended and how that boundary mapped on to this very amorphous terrain of broad state powers, these were all questions, and they emerged from very gritty fact patterns involving money, trade, ships, and merchandise. As the United States expanded, and roads and turnpikes and canals and then railroads unfurled from the Potomac to the Ohio and beyond, so too did law, layers of law, local regulation governing such things as the placement of distilleries, the location of piggeries, state legislation about banks, lotteries, and ports, and increasingly federal law in the form of international treaties, coasting statutes, enforcement actions, and import duties. The struggle over commerce quickly became a struggle to define the federal-state relationship. And crucially, interbellum Americans had to engage in constitutional creativity because the founders, the Constitution of 1787, simply did not provide clear answers. This is one of the main claims the book makes. The founders, as I argued in my first book, Ideological Origins of American Federalism, had a vision of federalism. And their vision of federalism consisted in agreements about structure. They agreed to divide authority between the federal government and the states. That was their reframing of sovereignty from many dominant British models. Where the line of division fell for the founders depended on what the particular subject was. So we can think of Article 1 of the Constitution telling us the federal government has certain powers, coining money, establishing post offices and post roads, declaring war, and so forth. And Article 1 also removes certain subjects from the purview of the states, treaty making, taxation of imports and exports, keeping troops or warships. But not all the subjects set forth by the Constitution were neatly apportioned in this way between the states and the federal government. The Constitution also sketched a substantial middle zone of powers. In this middle zone, competing governments operated, their powers overlapped. Both Congress and the states could claim the authority to regulate a given activity in this zone, which we can think of as a zone of concurrent power. In the interbellum period, As ports sprang up, as the river trade flourished, as the Union and its markets expanded, the zone of concurrent power also grew. And the concurrent powers of the Constitution became even more important because they governed some of the most significant areas of the nation's activity, including the power to regulate commerce, to regulate migration, and to tax. Each of these powers is mentioned in the Constitution, but the founders had left the boundaries around the powers undefined. And importantly, each of these powers also touched on the growing political and legal and economic crisis over slavery, in particular its expansion into new states and territories. Like commerce, slavery raised difficult questions of boundaries between federal and state power and between state and state power. Different states might have different regimes with respect to slavery, and in fact, they did. So Maryland protected slave owners' property rights in human beings, while Pennsylvania passed a series of anti-kidnapping laws intended to protect fugitives and free people of color. Questions about the extraterritorial effect of ostensibly local laws quickly melded into issues of slavery and interstate commerce. So now for the last few minutes, I'll turn to a case study in early 19th century debates about the commerce power, and one that I think is particularly apt for the Supreme Court Historical Society. This case study illustrates the creativity of interbellum constitutional discourse that we miss if we focus only on amendments, changes to text, or formal constitutional moments. This case study also demonstrates that 19th century federalisms, plural, were different from our own. So my case study concerns one of the most famous interpretations of the Commerce Clause, the Supreme Court's 1824 decision in Gibbons versus Ogden, the Great Steamboat Case, as it was known, which the court decided 200 years ago this year, and which I'm thrilled to note some of my students marked with a Gibbons versus Ogden party on the 200-year anniversary to the day. And they told me all about it. The Gibbons case was the first time that the court had explicitly addressed the scope of the commerce power. It came to the court after more than a decade of winding through the New York state courts. The case concerned many strands of argument, and it offers numerous possible visions of the federal-state relationship. I think we miss a lot of these when we just think of the casebook version, the excerpts, short kind of cash-out version that we might get, say, in a constitutional law textbook. So first, some facts. This is a fanciful view of New York Harbor a bit later in 1855. Note the flying machine overhead, so some creative license going on here. But this is roughly the setting of the Gibbons versus Ogden facts. The Gibbons litigation was the product of a decades-long series of disputes about navigation between New York City and Elizabeth, New Jersey. Aaron Ogden claimed a right to run steamboats on the Hudson River, which was known as the North River in those days. Ogden claimed under a monopoly grant from the New York legislature, dating back to Robert Fulton, the inventor of the steamboat. Ogden's opponent was one Thomas Gibbons, a transplanted Georgian, who in 1817 began running his own small steam ferry between Elizabeth and New York. A year later, the enterprising Gibbons acquired a larger steamboat. He hired the 24-year-old Cornelius Vanderbilt to pilot it. Ogden, in response, sought an injunction against Gibbons, which the New York court granted. They also fought a duel along the way because it was the early 19th century after all. But ultimately, the case progressed in such a way that Gibbons, the competitor, appealed to the Supreme Court of the United States through a writ of error. On February 4th, 1824, the Supreme Court took up the case. It was a sensational trial. This was not one where we say, well, we now know it was important, but people at the time didn't really think it was that big of a deal. This was a very monumental case, and people at the time thought it was so. Celebrities were in the courtroom, an all-star team of lawyers. The gallery was crowded with ladies and other people from Washington City and further out into the neighboring states. And here were the lawyers, three of them, three of the four. So who were the all-stars here? First, we have in the top left, United States Attorney General William Wirt, moonlighting in one of his frequent private appearances on behalf of his own clients. We also have Daniel Webster, representing Gibbons, versus Thomas Addis Emmet and Thomas Oakley for Ogden. So at the time of Gibbons, Wirt, who's one of the major characters in my book, Wirt was in the midst of what would end up being 12 years of service as U.S. Attorney General, a still unsurpassed record. He was also a 51-year-old father of 10 children. He was the possessor of a demanding legal practice, and he was a famed man of letters. He was a very busy man who managed to do quite a lot of things. Thomas Addis Emmet, who you see over on the right, was an Irish emigre, a native of rebel Cork, who had fled his home country to avoid prosecution because he was a member of the Revolutionary Society of the United Irishmen. Oakley, Emmet's co-counsel, was a former New York Attorney General who later became a state court judge. And Daniel Webster, looking dark and brooding in this portrait down at the bottom, was a Massachusetts congressman very much on the rise, who had already appeared before the court in several important cases, including McCulloch versus Maryland and Dartmouth College versus Woodward. Over the course of the 4-day-long argument before the court, which is just an interesting fact to note, the lawyers' greatest creativity came in their efforts to map the boundaries of federal and state power over commerce, and to clarify where the border between the two lay. Interestingly, there were no written briefs in the sense that we now understand them. Just speeches, hours of unbroken speeches, some of them extending over multiple days. And the lawyers referred to them as speeches, which I think tells us a lot about what the setting in the courtroom was like. Not arguments, but speeches. 3 principal competing approaches emerged over the course of the Gibbons arguments. One view insisted that the power to regulate interstate commerce, whatever that was, lay exclusively in Congress. And so states like New York had to stay out altogether. They couldn't license steamboats, they couldn't license any other type of company that engaged in interstate commerce. This was Daniel Webster's argument: total and exclusive federal power in any domain covered by the Commerce Clause. Attempts at concurrent power, Webster shrugged off. He said they would end in confusion and perpetual hostility. He professed not even to understand what such an approach would mean. He spent a lot of time in his arguments disavowing the workability of any sort of system of concurrent power. So that was Webster's argument. A second view allowed more room for the states to act under the heading of their traditional powers over health, safety, and welfare, known as police powers, or perhaps under some general power that they might have to regulate commerce within their borders. This was the argument that the Irish rebel, Emmet, offered on behalf of Ogden and the New York monopoly. Emmet argued that a survey of state laws across all the states at the time would reveal that, as he put it, they have always exercised the power of making very material regulations respecting commerce. In Emmet's view, this immense mass of state laws amounted to a body of regulation of commerce. If the power of Congress was exclusive, as Webster argued, the necessary result, Emmet said, would be declaring to be unconstitutional an appalling body of state legislation. Emmet's theory of concurrent power is very interesting, and it bears further investigation because it wasn't just another argument for saying states' power, states' rights, or the union as a compact. It was a theory of concurrent power, insofar as it allocated authority over a single subject, commerce, to both Congress and the states. Both levels of government would share regulatory authority over whatever this thing called commerce was, and they would have to negotiate the scope of their respective zones. Norms, practice, and judicial intervention would be required. Now for the third view. The third view was at the time the most innovative, and it was the least categorical. It also happens to be the modern legal rule in Commerce Clause cases, as many people here probably already knew. This approach allowed broad power to the federal government, but also held that states were free to regulate interstate commerce as well. The view accepted that a certain amount of sifting between state and federal claims would be required. It also assumed that the courts, especially the federal courts, would play a leading role in defining the contours of the federal commerce power. In other words, this approach treated the commerce power as a concurrent power to some extent, but with clear supremacy in the hands of the federal government. This third argument was the handiwork of Attorney General Wirt, who completed the Gibbons tetralogy of arguments with a 6-hour speech across 2 days. In his Gibbons argument, Wirt offered a mediating solution between the theories of his co-counsel, Webster, and their opponents, Emmet and Ogden. And in the letters, you can see that Wirt, arguing last, felt like he had to walk back Webster's arguments quite a bit, and Webster has a somewhat different account of the argument. So there was some competitiveness and jostling between the attorneys themselves. So the Attorney General, William Wirt, contended one need not believe that the federal commerce power was exclusive in order to find that Gibbons's boats could lawfully operate in New York waters. Some commercial powers were exclusive, but others were not. Even assuming that the states retained some concurrent power to regulate commerce, they couldn't do so in a way that obstructed the exercise of congressional power. So we can think of this as a version of modern preemption doctrine. Citing Hamilton's Federalist 32, Wirt suggested a different formulation from Webster's or Emmett's. Perhaps, he suggested, the field of commerce was so broad that it comprised two domains, one that was exclusively allocated to Congress, and another that belonged to the states in their capacity as guardians of the public welfare. The subject of commerce was, he argued, susceptible of division. Some of the commercial powers were exclusive in their nature, and among them is that power which concerns navigation. With this synthesis, Wirt clarified Webster's argument, as well as providing a framework that avoided an all-or-nothing choice between the commerce versus police and federal versus state dichotomies. So far, so much constitutional law doctrine. But then came a moment in the arguments that reminds us that the past is indeed a different country. And these, I think, are some of the most fun moments for historians. At the end of his 6-hour-long speech on the final day of the proceedings in the case, Wirt ended with a masterly rhetorical and literary flourish. The passage demonstrates why he was considered one of the preeminent members of the Supreme Court bar of the day, and exemplifies the degree to which the interbellum period was the era of constitutional oratory. At the culmination of the other side's case 2 days earlier, Emmett, the eloquent Irishman, had closed his remarks with a peroration out of the rhetoric books, and they all did read the rhetoric books. As the newspapers reported it, you don't get this from Wheaton's reports of the case, but the newspapers published at the time do show this. Emmett delivered an encomium to the state of New York, which had granted the original steamboat monopoly. Here's Emmett. The state of New York, by its liberality and munificence, has called into existence one of the greatest and most useful inventions of modern times, that of navigation by steam. Its benefits and the signal services of its author were not confined to New York. They had extended to every part of the Union. The waters of the Ohio, of the Mississippi, of the lakes, nay more, of the ocean itself, bear on their bosoms this trophy of genius, that being the steamboat. New York's generosity and foresight, according to Emmett, had given the steamboat not only to the United States, but to the world. The ties of commerce and affiliation that followed were the consequences of this virtuous action by the state. Emmett's language soared to its conclusion. New York might proudly lift her head, personifying the state, and survey the blessings which her munificence had scattered over the whole earth. Appropriating to herself the language of Aeneas, she might very properly exclaim, here I will not follow Emmett in giving the Latin quotation, but I will translate. Emmett delivered a quotation in Latin from Virgil's Aeneid. And in English, what Emmett said was, Aeneas stopped and weeping cried, is there any place, Achates, any land on earth not full of our sorrow? Now, I would love to have been in the room when this occurred, because one can only imagine how this oratory from Emmett thrilled his opponent, William Wirt, the man of letters. And Wirt remembered his boyhood Latin. Rising to address the court, the ladies, and the press, Wirt deployed it. Taking up Emmett's invitation to return to the classics, Wirt laid out his argument for the necessity of a national commerce power as a bulwark against the naked animosity that states like New York, New Jersey, and Connecticut had displayed toward each other. And indeed, there had been acts of retorsion, as they were called, passed by each of those state legislatures to fend off New York's monopoly or to exert retaliation against New York for punishing ships from other states. So Wirt first observed that his learned friend had eloquently personified the state of New York, casting her eyes over the ocean, witnessing everywhere this triumph of her genius, and exclaiming in the language of Aeneas. Wirt, however, then begged to correct Emmett's translation. Here's Wirt. It was not in the moment of triumph, nor with the feelings of triumph, that Aeneas uttered that exclamation. It was when, with his faithful Achates by his side, he was surveying the works of art with which the palace of Carthage was adorned, and his attention had been caught by a representation of the battles of Troy. The whole extent of his misfortunes, the loss and desolation of his friends, the fall of his beloved country, rushed upon his recollection. So word turned Emmet's imagery against him. The passage from Virgil recounted the aftermath of destruction, not a moment of victorious celebration. Emmet had unwittingly helped Wirt make his case. And among other things, Gibbons is a case study for attending to context when quoting primary sources. The full quotation from the Aeneid, which again was being lobbed back and forth in the Supreme Court chamber on this day in 1824, painted a stark picture. It was a choice between free-flowing, federally supervised commerce or parochialism, economic balkanization, destruction, and war. Upholding the New York steamboat monopoly, Wirt argued, would lead to the loss and desolation of New York's fellow states, and perhaps the fall of her country. Your country will be shaken with civil strife, Wirt said. Your republican institutions will perish in the conflict. Your constitution will fall. The last hope of nations will be gone. Wirt therefore urged the court to prevent this disastrous result, a nightmare vision of a broken union in which states were perpetually engaged in commercial war, and perhaps even outright violence against each other. All the court had to do, Wirt said, was interpose its friendly hand. Less than a month later, on March 2nd, 1824, the court made a friendly interposition on behalf of national commerce. The sole question in the case, as Chief Justice Marshall framed it, was, can a state regulate commerce with foreign nations and among the states while Congress is regulating it? The answer, according to Marshall, was an emphatic no. Instead, the court embraced a robust, even muscular vision of the commerce of the Union. Commerce, Marshall wrote, undoubtedly is traffic, but it is something more. It is intercourse. It describes the commercial intercourse between nations and parts of nations in all its branches and is regulated by prescribing rules for carrying on that intercourse. In February, asserting that commerce was intercourse and that it covered steamboat navigation was a lawyer's gambit. In March, commerce had become intercourse as a matter of law. The court had adopted a vision of a commercial union that it seemed to believe would stave off fragmentation and violence. And in a concurrence, Justice William Johnson offered an even more full-throated defense of the commerce of the Union. And often we don't look at the concurrences in Marshall Court cases, but Johnson's are always worth looking at. So why does this tale of early 19th century commerce matter? I would say for three reasons. First, in order to have a complete understanding of US constitutional law, it's imperative not to lose sight of the constitutional creativity of these decades between the big stories of the founding and the Civil War, the constitutional flyover country of the interbellum period. During this half century, the central public debates in America centered on issues that raised profound federalism questions, commerce, migration, and slavery, among others. Second, the period reminds us that the meaning of the Constitution was not settled or fixed in 1787. Important and unsettled questions were being debated for the next decades, and indeed today. The best way to gain purchase on the meanings, plural, is to listen to these debates, to listen to producers of constitutional discourse, people outside the court, other writers, other thinkers, other people who were participating in debates. Their statements not only provide evidence of meaning, they were speech acts in which meaning was being created at the time. Examining the cases in this broader context affords a broader view of the landscape of constitutional possibility at a particular moment in time. Finally, the period's important because it helps give context to our own moment of intense political and legal debate. Many commentators increasingly have cited the Civil War or the immediate years preceding it as an analogy to and a cautionary tale for our current moment of polarization. But the more accurate benchmark is the 5 decades of simmering constitutional conflict that came before the war broke out. The similarities between those years and today provide context and insight and perhaps a warning to all of us. On the eve of the Civil War, President Lincoln proclaimed in his first inaugural address in 1861, "The union of these states is perpetual." he might as well have added, conflict about the structure of the Union is perpetual. For so it has been ever since the Constitution's drafters laid down their pens in 1787. Thanks very much, and I look forward to taking questions.
Thank you very much, Professor LaCroix. It's fascinating, and you focused today on the commerce portion of your analysis of federalism, and it's a very thorough study of it. You also address other issues within the context of your work as examples of federalism and other federalisms. Would you mind just briefly touching on the other issues that you've raised in the realm of federalisms? And then I have some more specific questions about the tensions between state and federal governments, not only from that time frame, but today.
Yes, well, it's true. I mean, I think commerce is one of the big, as I say, battlegrounds, but there are other domains as well. And even within what we might think of as the Commerce Clause, plural. So when we look at the relationship between not just the federal government and indigenous nations in this period, so thinking of the Cherokee cases, Cherokee Nation versus Georgia, Wooster versus Georgia, but also the fact that that was a kind of, there were many more parties to that dispute. There was also the state of Georgia. And so one of the things that I try to talk about in those two chapters are the ways in which you have a state, in that case, Georgia, claiming sovereignty and saying, well, look, the lesson we learned of the American founding was that you can have the federal government and you can have the states. And that's not a problem for theories of sovereignty. That doesn't create what had been called an imperium in imperio, which was Blackstone and other people in the 18th century's phrase for something impermissible. But Georgia basically said, the splitting of sovereignty or the other kinds of polities stops with the state. And so they then used that argument against the Cherokee Nation and many other native nations to say, you can't possibly exist within the territorial boundaries of Georgia. And then we get the Cherokee leaders like John Ross and Elias Boudinot and others, and their lawyers in the Supreme Court, one of whom is William Wirt, a ubiquitous figure in the period, and therefore in the book, who make all kinds of creative arguments. Wirt at one point says, what about Washington, D.C.? That was carved out of Maryland and Virginia. Isn't that an imperium in imperio? Why can't we have a nation state, or if not a nation state, what Chief Justice Marshall called a domestic dependent nation, like the Cherokee Nation within Georgia? So that's another model, I think, of this. They're kind of jumping off from some things in the Constitution, like the Indian Commerce Clause, but really thinking creatively about federalism. And I call that a theory of fractal federalism, where you can have something that's a nation within a state that's within another nation. And there are really valid kind of live arguments being made at the time for that being possible within the framework of the US Constitution as they knew it.
Interesting. You mentioned also in your book the more traditional views of federalism today and the tensions between state powers and federal powers, and identifying federal power more with liberty and state powers more with restrictions on liberty. But that isn't actually, it's certainly true in the realm of slavery and the debate that occurred then and in the aftermath. But there are other areas in which that isn't exactly, it doesn't work out that way. That is, could you give some examples of where state and local powers are, in fact, sometimes more libertarian, if you will?
Yes, and I think that's one of the other central arguments I try to make in the book, which is part of a lot of the standard story of this period reads the antebellum period, even as that term suggests, through the lens of the Civil War, and then says, well, everything we find in the Civil War and after comes in this antebellum period. So certainly it's true that when we think of the Union Army and we think of Reconstruction and the national government, those are all forces that are arrayed against states that are trying to continue or protect slavery or then kind of continue something that's forms of discrimination and segregation in all but the sort of name of slavery for years afterward. But one thing that's very notable about the interbellum period, when we look at it in its own terms, is the way that that intuition is flipped. So it's not necessarily the case that the federal government in this period is always on the side of anti-slavery. And I think we can mistake that if we read it through the lens of what came after. So, for instance, one thing that's worth noting is that throughout much of this interbellum period, the literal institutions of the federal government are controlled by Southern slaveholders. And we have to think of that as a much broader term too, encompassing states that don't end up necessarily being part of the Confederacy, Maryland, Missouri, and others. But the domination of the federal government for political reasons and constitutional reasons, including the 3/5 clause, lots of things kind of in the text of the Constitution that gave them outsized power over Congress and the presidency and also the court. And then the last chapter of the book is a really fascinating episode in which you have a state, in that case, Wisconsin, although there were other states that engaged in similar behavior. Wisconsin makes the most robust states' rights arguments. If you took away the name of the state and you just said, who's making this argument, people would think, oh, this is probably South Carolina nullificationist rhetoric, or it's the eve of the Civil War. But it's not. It's Wisconsin. And the Wisconsinites are claiming states' rights and state sovereignty against federal power, because federal power is behind the Fugitive Slave Act of 1850. And in this particular instance, the rescue and escape of Joshua Glover. Joshua Glover is a fugitive, a formerly enslaved man who self-emancipated, got to Racine, Wisconsin, and then is seized under the auspices of the Federal Fugitive Slave Act. So his putative slave owner comes and captures him, kidnaps him, drags him to Milwaukee, under federal authority, jails him, and then state and local officials and a mob break Glover out of jail, help him escape, help him get to Canada. And then you get these years that culminate in a Supreme Court case, Abelman versus Booth of 1859, where Wisconsin is lobbing the most nullificationist, disunionist, states' rightsist rhetoric at the federal government that one could imagine, in the name, though, of liberty for Glover and other fugitives. So again, I mean, it's interesting when I teach that material, I think students and many of us have a tendency to read it and say, well, the Wisconsin people don't really mean it. They're just kind of using states' rights rhetoric because they know that that will maybe win them what it did, a unanimous Supreme Court in Abelman in 1859. But they really feel it. I mean, when you look quite deeply at the way those arguments are made, there is a states' rights argument that states like Ohio, Pennsylvania, Wisconsin are making. So that's one area. I think that just totally flips and scrambles our sense of sort of who's on which side of some of the big debates. And then we also see it in other areas too, less charged, but merchants, for instance, in Baltimore, challenging federal regulation and saying, well, look, this federal law about imports and exports shouldn't apply to us. Interesting debates within states as well about the state legislators who might be in one city, but the port merchants who are in a different city, and they have different interests as well.
This is an enormously important piece of work that you've done, I think, because it really puts in proper balance the whole, or not only the origins of the country and federalism, but what we wrestle with today. And I think that perspective is really very much needed today. You alluded to, the views of polarization today. I think if more people understood the balances of power and the distribution of power among the shared forms of government in our system, I don't know if we get along better, but we'd be more informed about our debates and arguments. So I think your work is really vitally important, and I congratulate you for it. We did have a few other questions that I might get to. What are your views about Daniel Webster?
Well, he's an interesting character. I think So he's an interesting one too, in terms of how we understand him in the historiography. I think, in 1830, he gives his famous reply to Robert Hayne, in the Senate, and says, liberty and union, one and inseparable, now and forever. And so he's often taken to be a spokesperson for a very aggressive, kind of robust national power. But then later on, that's 1830, in 1850, he's one of the chief architects of the legislation known as the Compromise of 1850, one piece of which is this Fugitive Slave Act of 1850. And so he's a Massachusetts, he adopts Massachusetts. He's originally from New Hampshire. He's a New Englander, but he views compromise as worth making, compromise with, the Southern plantocracy. And so it's consistent with his union view in some ways, because he privileges and puts the union above all else. But he took a tremendous amount of criticism in his own time and in the historiography afterward for those compromises, for sort of putting federal power in the hands of this supposedly local or sectional interest. The part of his career that I also find quite interesting is his time as a Supreme Court advocate. So he lived longer than William Wirt, and they were co-counsel in a number of cases. And so, as I mentioned in Gibbons, you can read each of their accounts of how those oral arguments went. And they're quite different. So I think of them as frenemies, really competitive. Webster has these asides sometimes about, well, Wirt's a pretty good lawyer, but, or I was speaking, says Webster, and I could tell that Chief Justice Marshall was drinking in my arguments like mother's milk, I think he says at one point. But, in some ways, like, the proof is in Wheaton's reports, because Gibbons, for instance, Justice Johnson in his concurrence adopts the Webster view of exclusive federal power. But it's Wirt who says to the court, look, you don't have to go all that way. You can say, basically, preemption, supremacy clause, hang your hat on this federal coasting statute. You don't have to say all commerce power is in the hands of the federal government and Congress. So I think it's an interesting study in the significance of the lawyers, actually, and how, if we only read the opinion of the court, we miss what I think of as all the plausible arguments, because these are lawyers who have hours and hours to speak. They're zealous advocates, so they're going to throw everything at the wall. And so for me, as an intellectual historian, you read their arguments and you get a very good map of what they thought could possibly stick to the wall.
Interesting. Couple other questions we have. What is the role of internal improvements in the midst of the interbellum federalism?
Hugely important. So we could think of these also as public works projects, but in the terminology of the day, internal improvements. And so this is roads, canals, turnpikes, later railroads. So I showed the slide of the Erie Canal. The Erie Canal was funded entirely by New York state funds, which was part of New York's Empire State kind of identity. And it became the envy of all the other states that didn't have the money to build a canal, and they didn't have the geographic situation either. So there's this constant debate throughout this period about, may Congress fund internal improvements? Could it fund them and then operate them? And so this is like, for instance, the Maysville Road or the National Road or the Cumberland Road. So we know President Monroe vetoes one of these bills. He sort of changes his mind and vetoes an act of Congress that would have let Congress fund them. Jackson issues the famous Maysville Road veto in 1830 and says it's too local, setting in motion several centuries of debate about when is something too local. But one thing that's notable is people generally agreed that the internal improvements were a good idea. It was this question about who could fund them. And I like to point to this also as an example of how different their constitutional world was, because they think it's a good idea, but they think, and Madison was writing about this at the beginning of the interbellum period, corresponding with people like Martin Van Buren and Andrew Jackson, who were seeking his advice. And Madison's like, well, they would be a good idea, but probably Congress doesn't have the power to do them. If we think of things like the federal highway system today, of course we think Congress has the power to do this. And then the workaround they ended up using for railroads and such was something that I think we would not think Congress could do today under its spending power. So yeah, I mean, it is a physical manifestation, I think, of a lot of these debates about federal power.
I think we have time for one, maybe two more questions. One, let's see, was Lincoln's interpretation of the Commerce Clause the reason he initially insisted on slaveholders being compensated?
Well, I think a lot of that sort of early stage Lincoln, and this is now sort of on the eve of his election, and then even into the first few months of 1861, when he was willing to contemplate things like compensation or the Corwin Amendment, which essentially would have said slavery is protected where in the states where it currently exists, was because it does connect, I think, to his view of the commerce power and also Congress's power under the kind of federal lands provisions of the Constitution, that when you're talking about the territories, those are plenary under Congress's plenary power. So he was distinguishing between states and territories in a kind of legal way.
Mm-hmm.
But I think he was also doing it politically because, especially as states started seceding, the first 2 years or so of the war, and even into the Emancipation Proclamation and later, Lincoln politically trying to keep Maryland, Delaware, and Missouri from seceding, and therefore having to, we could think of it as compromise or do things like not have the Emancipation Proclamation apply to them because he didn't want to antagonize them into seceding. So there's a political and there's a kind of legal doctrinal component as well.
Mm-hmm. Well, this has been great. Tell us what's your next work? What next will you do to save the Union?
Well, I think when I've ended a book on the cliffhanger year of 1861, I have to proceed forward. So I've realized I'm writing a federalism trilogy here, I think. So the first book was the founding period up to about 1800. Now this one, 1815 to 1861. So I've started working on the Civil War and Reconstruction. And I think right now, especially those early months, years of the Civil War, there's so much there. There's so much that changes rapidly. And again, the kind of everything that comes after sometimes I think leads us to maybe misread some things. So that's where I'm heading next.
Well, I can't wait. Can't wait to read it. I think your scholarship has a very practical impact, and I really highly recommend it to all to read your book. And I'm going to hold it up here, and you can get it from our gift shop at the Supreme Court. It is The Interbellum Constitution, Union, Commerce, and Slavery in the Age of Federalisms. And you may purchase that on our website at www.supremecourtgifts.org. We're very grateful for your time today, Professor LaCroix, and we thank you very much for joining us. The Society is celebrating our 50th anniversary this year, and we have two exciting virtual programs coming up to launch our commemoration as well. On June 11th, I will be in conversation with Jeffrey Rosen about his new book, Pursuit of Happiness. This is an exclusive event for the Society members only. And on July 16th, I will be joined by the Society's Director of Publications, Claire Cushman. She and I are going to discuss the Society's founder, Chief Justice Warren E. Burger, and his vision for the judiciary. Registration for both of those events are open on the Society's website at www.supremecourthistory.org. And finally, today, a survey will go out later this afternoon to everyone who who registered in advance. We hope you will agree to respond to it. We've added these virtual programs during the pandemic, and they were such a big hit. We plan to continue them. And today's was another in the series, and we're very grateful for Professor LaCroix's participation. Your feedback is also very helpful to us. We want to make these as informative and engaging as possible. So we thank you all for joining us today. Thank you, Alison, and we are adjourned.
Thank you.